law that you will apply to the facts and evidence you've heard in this case.
Okay.
You will each get a copy of the charge so that you can review it. Don't worry, you're not going to be quizzed on this. You'll get a copy of that. But before I go any further, the notes you've been taking will be taken before you go back to deliberate. The reason being is that the official transcript of the court is what Mr. Shetler has taken. The reason we give you notes is because some people remember things when they write it down. I know I do. But the official record is the record of the court. In cause number 1765224, the state of Texas versus Adolfo Serrano in the 177th District Court of Harris County, Texas, May term AD 2022. Members of the jury, the defendant Adolfo Serrano stands charged by indictment with the offense of intoxication manslaughter, alleged to have been committed on or about the 2nd day of April 2022 in Harris County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of intoxication manslaughter of a peace officer if the person, 1, operates a motor vehicle in a public place, and 2, is intoxicated, and by any reason of that intoxication causes the death of a peace officer while in the actual discharge of an official duty by accident or mistake. Public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartments, houses, office buildings, transport facilities, and shops. Intoxicated means A, not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body, or B, having an alcohol concentration of 0.08 or more. Alcohol concentration means the number of grams of alcohol per A, 210 liters of breath, B, 100 milliliters of blood, or C, 67 milliliters of urine. Motor vehicle means a device in or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Peace officer means a person elected, employed, or appointed as a peace officer under Article 2.12 of the Code of Criminal Procedure. The following are peace officers. 1, sheriffs and their deputies. 2, constables and their deputies. And 3, marshals or police officers of an incorporated city, town, or village. Voluntary intoxication does not constitute a defense to the commission of a crime. Now, if you find in the evidence beyond a reasonable doubt that on or about the 2nd day of April 2022 in Harris County, Texas, the defendant Adolfo Serrano did then and there, unlawfully, by accident or mistake, while operating a motor vehicle in a public place while intoxicated, and by reason of that intoxication caused the death of Jennifer Chavis, a peace officer in the actual discharge of an official duty, by driving his motor vehicle into and causing it to collide with a motor vehicle occupied by Jennifer Chavis, then you will find the defendant guilty of intoxication manslaughter as charged in the indictment, unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in this indictment. You're not to consider that evidence in determining the defendant's guilt of the charged offense. Our law provides that a defendant may testify on his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, the fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you're instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take into consideration for any purpose whatsoever as a circumstance against him. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It's not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he's been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence whatsoever. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all of the evidence in the case. The prosecution has a burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you, and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given their testimony. But the law you shall receive in these written instructions, and you must be governed thereby. After you retire to the jury, you should elect one of your members as your foreman. It is his or her duty to preside at your deliberations, vote with you, and when you've unanimously agreed on a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as foreman. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No one has any authority to communicate with you except the officer who has you in charge. After you're retired, you may communicate with this court in writing through this officer. Any communication relative to this cause must be written, prepared, and signed by the foreman, and shall be submitted to the court through this officer. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. Your verdict must be unanimous, but must be by unanimous vote of all members of the jury. Following the arguments of counsel, you retire to consider your verdict. Attached to this jury charge is a verdict form which reads, "We the jury find the defendant Adolfo Serrano not guilty," or "We the jury find the defendant Adolfo Serrano guilty of the intoxication manslaughter as charged in the indictment," and it will be signed by the foreman of the jury. There is a special issue which states, "Now, if you have found the defendant guilty of the offense of intoxication of manslaughter, you must then determine beyond a reasonable doubt whether or not he used or exhibited a deadly weapon, namely a motor vehicle, during the commission of the offense or during the immediate flight therefrom." A deadly weapon means anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. The prosecution has the burden of proving the defendant used or exhibited a deadly weapon, namely a motor vehicle, during the commission of the offense or during the immediate flight therefrom, and it must do so by proving it beyond a reasonable doubt. And if it fails to do so, you must find that the defendant did not use or exhibit a deadly weapon, namely a motor vehicle, during the commission of the offense or during the immediate flight therefrom. It is not required that the prosecution prove use or exhibition of a deadly weapon, namely a motor vehicle, beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's use or exhibition of a deadly weapon, namely a motor vehicle, during the commission of the offense or during the immediate flight therefrom. In the event you have a reasonable doubt as to whether the defendant used or exhibited a deadly weapon, namely a motor vehicle, after considering all the evidence before you and these instructions, you will find the defendant did not use or exhibit a deadly weapon, namely a motor vehicle, during the commission of the offense or during the immediate flight therefrom. If you, the jury, find beyond a reasonable doubt that the defendant used or exhibited a deadly weapon, namely a motor vehicle, during the commission of the offense for which he has been convicted or during the immediate flight therefrom, the jury will either answer "we do" or "we do not," and you will write the answer in the answer line. And that will also be signed by the foreman of the grand jury. We will now proceed to closing arguments. State?
Thank you, Judge. May I have a brief moment to prepare?
Yes, of course.
know it's only Thursday, but we've had a lot of heavy information, over the past 3 days. Information that will probably stay in your mind for the rest of your life. Now, at the beginning, when we first met all of you, when Sean and I were doing voir dire, we went over the elements that we have to prove. And I'm going to go over these elements with you, over all the evidence that we've learned in the past 3 days. And then the defense is going to get up here and have a chance to talk to you. And then I'm going to come back up here. It's our burden, so we're allowed to go first and last. Okay? Now let's talk a little bit about each of these elements that we've gone through in the past 3 days of testimony. On or about April 2nd of 2022. I don't think that's in question here, right? Every single person that testified came up here and told you that Jennifer lost her life on April the 2nd of 2022. In Harris County, Texas, again, I don't think that's any kind of element in question. Several of the officers told you this is in Harris County. You saw the map of where it happened. You saw the dash cam from Brett Hunter of the location and where it was at. Adolfo Serrano Jr., the defendant, multiple people got up on the stand and identified that man, Adolfo Serrano Jr., as the person that was driving that truck that day. He identified himself, right? So first we had Josue get up there and tell us that that was the man that was driving the truck. We had Officer Price identify him. That was the man that he took into custody. We had Sergeant Niger get up and tell us that was the man that I conducted those standardized field sobriety tests. And you all saw the body cam videos. You all saw that that is the same person sitting here. By accident and mistake, this is one of those things we talked about in voir dire, that we're not alleging an intentional crime here, right? There's no mens rea that is required to prove. Operated a motor vehicle. Let's talk about all of the ways that we've proven to you that he was the person operating that vehicle. Josue saw him get out of the driver's seat that day. And then he tells the people, when he's sitting in the back of Officer Jones' patrol vehicle, he tells us that he was driving the vehicle. And then we played a jail call for you guys where he also admits that he was driving the vehicle that day. And then, just to show that an entire investigation was done, we brought our DNA analyst up here to tell you that after Officer Chavis took those airbags from the defendant's vehicle, we had the DNA tested, and the DNA came back to Adolfo Serrano, right? Now, I'm not sure what they were getting at with the DNA analyst. Like, somebody may have snuck in and placed his DNA in there, which was completely unnecessary, because we all know that he was driving the truck. It's his truck. There's no reason to question that, right? We're just bringing scientific evidence that is validating the other evidence we have that he was driving the vehicle that day. Then we move on to in a public place. By very definition, this is a public place. By very definition, a street, a highway is a public place. While intoxicated. Now I want to talk to you about all of the different ways we proved he was intoxicated that day. And I want to start with Brett Hunter, the civilian who was following him for 12 miles. And the behavior that all of you got to witness yourself by watching that vehicle. A civilian with no law enforcement training whatsoever called 911 to say, I'm following somebody who's intoxicated and he's gonna kill somebody. He makes that statement not knowing that in just a few minutes that was absolutely going to be true. We watched the defendant go through lanes of traffic, back and forth, over and over again. We watched him hit a wall at some point during the video and almost hit the wall a second time. We watched him almost hit a motorcycle in that vehicle, almost hit several other cars in that vehicle. And you learned when Ben Troyer, Deputy Ben Troyer, got up there, a drug recognition expert, he told us that driving behavior is classic signs of somebody who's intoxicated. And Brett told us about how the defendant would go faster and slower, and how it was never a consistent speed that he was going. It was never a consistent speed or direction. All signs, classic signs of somebody who is driving while intoxicated. Then we got to Josue, the tow truck driver. And he told us that when he made contact with Adolfo Serrano Jr., he had slurred speech. He smelled like alcohol. He was unsteady on his feet. So unsteady that he could just hold a hand here to keep him from getting up. And then the next person who makes contact with him, Deputy Price. Deputy Price tells us the same thing. He tells us he smells alcohol on him. He's got red bloodshot eyes. He's unsteady on his feet. And in fact, you actually see him fall on Deputy Price's body cam. And they tried to make it seem like he's walking on the side of a mountain over there, when in our other evidence pictures, you can clearly see that there is a flat surface for them to be walking on. And everybody else is walking across there just fine. But Adolfo Serrano Jr. can't walk straight because he's highly intoxicated. And then we had Sergeant Niger. When Sergeant Niger went to the hospital to do standardized field sobriety tests on the defendant, he talked about the same thing. These are all people who don't know each other. Sergeant Niger works with the Harris County Sheriff's Office. We have a tow truck driver, a random civilian, Precinct 7 deputy. None of these people know each other, and they're all making the same exact observations. He smells the alcohol. He notices that his eyes are bloodshot. Then he starts doing that standardized field sobriety test, the horizontal gaze nystagmus, right? Something that tolerance doesn't affect. And when he does that horizontal gaze nystagmus, because of the position he's in, you guys can actually see the nystagmus clearly on the body-worn camera. You can actually see how severely his eyes are bouncing because of his high level of intoxication on Sergeant Niger's body-worn camera. And after he makes those observations, he goes and retrieves a search warrant for the defendant's blood. Then we have the blood draw. And if all of the other stuff wasn't enough, we brought you more scientific evidence to validate everybody else's observations. That crash happened at 1744, 5:44 p.m. We weren't able to get a blood draw until after 10 p.m. That blood draw happened at 22:17, 10:17 p.m. That is 4 hours and 33 minutes after the crash. 4 hours and 33 minutes after the crash. this defendant, was a 0.16 blood alcohol level. 0.16, over twice the legal limit. 4 hours and 33 minutes later. Then we had a toxicologist come and talk about absorption and elimination of alcohol in the bloodstream. And she told us that he would absolutely be eliminating that far after the crash. And she told us that the normal elimination rate for humans is between a 0.01 per hour to a 0.025 per hour. So let's talk about a reasonable inference we can make from that information. If we give him the strongest benefit of the doubt that he is the slowest eliminator and only eliminates 0.01 out of his bloodstream per hour, he's over a 0.2 at the time of that crash. Well over what we are legally required to prove to you at a 0.08. All of those other things that all of the other officers and civilians told us that they observed, the things you observed on that dash camera, that's all loss of the normal use of mental faculties and physical faculties that we all talked about in voir dire. The inability to do the divided attention that is required of us when we drive a motor vehicle. So we proved it that he lost his mental faculties, he lost his physical faculties, as well as he's well above a 0.08 BAC. By reason of that intoxication caused the death of Jennifer Chavis, the complainant. I want to talk to you a little bit about this. They did a lot of victim blaming of where she's sitting. They found some random guy, don't know where they found him, some random guy that decided to get up here and say, I went to the location and parked my vehicle on the shoulder. And I didn't get hit. Let's talk a little bit about that. There's a lot of pictures of this in evidence, but on State's Exhibit 64, we've heard lots of testimony about how this mark right here is our area of impact, right? Well outside of a moving lane of traffic. We had multiple officers come up here and tell you that this is a very normal place for officers to sit. It's a normal place for people to change tires. It's a normal place for officers to sit there to wait to make traffic stops. It's something that they have all done and continue to do. I guarantee you, all of you have seen police officers sitting in that exact spot. There is no reason why she should have been unsafe sitting in that spot. The only reason that Jennifer Chavis is dead is because he decided to drive highly intoxicated. That is the only reason. She came responding to that call to try to protect other people from exactly what happened to her. It doesn't matter. She could have been actually sitting in a moving lane of traffic and have been safer because he would have missed her at that point. All the sober people saw her, but the intoxicated person didn't. Not only did he not see her, he drove over 4 lanes of traffic to get to her. That is not normal driving behavior. And then he's so intoxicated that he's telling them, oh, the car was already on fire. And we all saw the video and know that is not true. That car wasn't on fire until he struck it with a 14,400-pound truck that he drove coming from the strip club. A peace officer in the actual discharge of an official duty. We heard from Sergeant Scott. We heard from Deputy Price. We heard from Deputy Williams. They were all at work with Jennifer that day. And we all heard that she was responding to that call. She was actually about to go get her car washed. And she chose to go on that call. By striking her with his motor vehicle. I don't think that's in question, guys. It's on video. We've proved each and every element beyond a reasonable doubt. And we are going to ask you to go back there and find him guilty at the end of this.
You may proceed.
I'd like to thank counsel talking about beginning her argument about the gore, because I had not intended to talk about it. She has allowed me to segue into it, because no one who has testified in this case for the state of Texas has testified that it was in any way a normal place to be sitting.
That's not inaccurate.
The jury will call the evidence as they heard it.
Why was Deputy Chavis sitting in the gore? A nasty name for a very dangerous place at the time of the collision on April the 2nd, 2022. You know, it's a real simple question, but it seems to generate and augment anger and outrage from a lot of people. But it's a real simple question. Why was she sitting there at the time of the collision? It's important to understand that that question in no way disparages Deputy Constable Chavis. By all accounts, she was a wonderful human being. She was kind, She was loving. She was indeed a mother, a sister, and a daughter to her family. She was a wonderful human being, and this is a terrific tragedy for her family. But it does not take away from the question, why was she sitting there when there was another location just down the road that was protected? We heard an enormous amount of testimony over the last couple of days about the collision, and it started with Brad Hunter. He took us step by step, second by second, as to what he was observing, and he was transporting that information electronically to dispatch through 911. So we could hear through that audio video what he was observing, and that's important because that information then went out to law enforcement. We heard from Deputy Williams, we heard from Deputy Price, we heard from other folks, and we heard from an accident reconstructionist. And he testified about everything you would want to know about that accident on April the 22nd. He testified about weight, he testified about speed, he testified about what was in the vehicle, what was retrieved, what was recovered. Everything you can imagine. And then we heard from other witnesses as to how they responded to the collision and what they saw, what they felt. However, no one has testified as to why she was sitting where she was awaiting Mr. Serrano's vehicle. Now, we have heard from former Deputy Scott, who testified that she followed the protocols. She followed protocols. We all heard that. But let's talk a little bit about what we also heard about the protocols. What protocols? You heard from Deputy Williams, who talked about his training with Precinct 7. The bulk of his training came from his employment with Montgomery County. Montgomery County taught him how to deal with moving vehicles. Montgomery County taught him how to deal with their terrain, their roadways, their bridges. He had some one-on-one with Precinct 7, and then he was on his way. It was very interesting because when I spoke with Deputy Williams and I asked him about his familiarity with this part of town, he said two things. One thing, though, that he said was that his training in both with Precinct 7 and Montgomery County coincided, and that was with the concept, the idea that you are supposed to be behind the moving vehicle that you are expecting and will be chasing. Behind the vehicle, not in the path of the vehicle, not expecting the vehicle. And if that was the case, if that was the protocol that he remembered, because he no longer works there, then why was it that Deputy Chavis was sitting within her car ahead of the vehicle? Deputy Price may have had it right all along. Deputy Price didn't have very much to say. But essentially what he said was that he, when he was employed with Precinct 7, was given 2 weeks of training, and then he was left on his own. Nobody can remember anything about written protocols. They just remember who their trainer was, and they had 2 weeks of it. You know, it's interesting because the state of Texas, if I recall this correctly, at the very beginning of this trial, in their opening statement, made the comment that we would be hearing the last words of Deputy Chavis. We haven't. But more importantly, what I think is relevant here is that we have not heard any communication from any law enforcement agency or any civilian agency pertaining to communication from the time Deputy Chavis got into her car and parked inside the Gore. Nothing whatsoever. No communication. Nothing. No information. And why is that important? Because we don't know. We don't know what instructions she may have been receiving. Who instructed her, if anyone, to sit where she was sitting? We don't know what information she was receiving. We don't know if she may have disagreed with the location to where she was sitting and may have wanted to move. But for some reason, we have not heard any communication that was from anyone, either repeating what was provided to her or what she may have sent out. Nothing at all. We just have a parked car. So we don't know if she was instructed to sit there. We don't know what she saw. We don't know what she was thinking. And with this kind of information that Mr. Hunter was putting out, you would have thought that there would have been some kind of communication relayed either to Officer Chavis or from Officer Chavis. And we certainly don't know why she was not behind that protective vehicle barrier, because she was just a little ways up in the Gore when Mr. Serrano's car was approaching. What do we know? What do we know that she knew? She was told, because it came out in testimony, she was informed that there was a possible DWI. She was informed that the car was traveling at various rates of speed. She was informed as to the direction of the vehicle. And she finds herself ahead of the vehicle. Now, the state of Texas can disparage Mr. Marler all they want, the investigator that testified yesterday. But Mr. Marler had a very simple task, and that was to go out and take pictures of the Hillcroft entrance. And why did Mr. Marler have to do it? Because every time I attempted to talk about that entrance with law enforcement that had taken the stand, it was either, I'm not familiar with that, I don't remember what it looks like on the other side of the retaining wall, I can't give you any information, I don't know what that photograph is a picture of. So Mr. Marler rectified all of that by identifying the Hillcroft entrance. That was his job. That was it. And you don't need to be an expert in roadway engineering or traffic design or a patrolman or a police officer to see that that is a protected area. Now, we did get some information from law enforcement that, oh, I think it's a tight squeeze on the other side of the barrier. And what did Mr. Marler testify to? Something real simple, folks. My vehicle fit in the parking area right behind the sign. And I believe that is why that parking area is there. Otherwise, the grass would have gone all the way to the end. Now, Does it take a rocket science to figure out that you are protected on the left? No. The gore, there's a reason why it's called the gore. That is a very dangerous area, and it is totally unprotected, and you've got moving lanes of traffic on both sides. But here, it's protected, and there are other photographs that have been introduced to show that you can see above it to the traffic on the left. Again, this is in no way disparaging Deputy Chavis. A wonderful person, no doubt about it. But what I am doing is wondering why she is there. You know, at the end of the day, the state of Texas is probably going to say, she's going to stand up and say, hey, you can ignore everything that Mr. Godinich is saying. You can ignore everything that Mr. Pollan is going to say. We proved our case. You don't need to listen to anything the defense is saying. But you have to decide whether or not where Officer Chavis was sitting was any kind of a contributing factor to this accident. Not on a personal level, but on a professional level. Should she have been there? Should she have received better instructions from her supervisor? Nobody wanted to talk about this just down the road from where she was. Thank you. Mr. Pollan is going to follow me.
May it please the court.
Yes, you may proceed.
Fellow counsel, ladies and gentlemen of the jury. First, I want to thank you all for showing up for jury service, because you discovered, even though you got a subpoena, the jury service is really voluntary. You have to want to come down here. And if you all didn't come down here, we couldn't have jury trials. So, thank you. And you went through a lot with this case. We had a long voir dire, and you were very open and honest about the case. And you made a lot of promises to the state and to the defense about listening to all the evidence, being fair, don't make up your mind till everything's in. And also, we get to this point in the case, and if you haven't been on a jury before, this is where lawyers get to tell you our views and what we see the evidence as. But what lawyers say are not evidence, because the only evidence you heard was from the witness stand. First, I also want to say thanks for the professional way that the prosecutors have handled this case. They're both outstanding lawyers, and it's a pleasure to work with them. I'm sure we'll have cases next week, 2 weeks from now. But this, let me tell you briefly, Harris County Courthouse in criminal courts, it's like a small high school. Everybody knows everybody. Typically in law practice, you'll run into a lawyer on the other side once in your career. Here, it could be tomorrow, the next week. That causes, I believe, the lawyers to act at a much higher level than you'd find in the civil courts and family courts. And I've worked in those courts too, and they're entirely different. So that's a place for this system. I want to thank the judge for her efforts in this case too, to assist and expedite the case. Attorney's role in argument is to kind of give you our view of what the evidence was and what they've shown, and it's an essential part of the justice system in Texas and America. When you came in as jurors, you were asked a lot of questions, and I'm going to go over them again briefly. You said you presume Mr. Chavis innocent until proven guilty. You said you'd hold the state to its burden of proof. You said you would require the DA to prove all the elements involved in the case, which counsel's talked about beyond a reasonable doubt. You said that Mr. Serrano did not have to prove anything. In this case, the jury went over some interesting things. We talked about the levels of proof, and I think it's important to review those. We have 8 levels of proof in Texas, and there are different levels. It depends on what you're dealing with. We're going to put that up on the chart so you can see it. The first level is no evidence. Well, if there's no evidence, then the jury's duty is to find the person not guilty. That means no trace of evidence whatsoever. Next level is scintilla. That's any evidence at all, even the smallest amount of evidence measurable, and that's, you find the person not guilty if that's all they have. Reasonable suspicion. It should not be based on specific or particular facts or reasons and not based on hunch or guess. Again, if that's all we find, it's not guilty. Probable cause. Probable cause is how cases get filed originally by the state and reviewed by the judge when they come into court. But that's reasonable and trustworthy information that a person has committed a particular crime. But that doesn't get you convicted of a crime. Next is preponderance. That's the civil standard, greater weight of preponderance of the evidence. Doesn't get you found guilty. Clear and convincing is evidence that is used to terminate parental rights. It's a very high standard, but still, if that's all the state proves, it's not guilty. Then we get to reasonable doubt. And reasonable doubt doesn't get you convicted either. It has to be beyond a reasonable doubt. It's a very high standard, and the state, to its credit, it has embraced the burden of proof that they have in this case. I also want to tell you how, going through this case, and I have not been on the case as long as Jerome or the prosecutors, I came in later, it's a very difficult case to watch. Jennifer as all I can tell, was a wonderful lady. And the fact that she's no longer with us is a tragedy of significant proportions. It really, and I've handled, as counsel knows, I've been a lawyer for a long time. I've seen a lot of stuff. And you never get used to these kind of situations. You don't. You heard Jerome's comments to you, and I think he made a lot of significant and good points about the gore and with the dangerousness there, and whether the training was sufficient or not. Those are important to know to put the case in context. But if you look at elements, if you look at the elements of the case, and I boil it down to what the state really has to prove, the highlights. And this is from the jury charge that you'll be able to take in with you from the judge. And the state has to prove a person commits the offense of intoxication, manslaughter of a peace officer if the person operates a motor vehicle in a public place. Mr. Serrano operated a motor vehicle in a public place. That's not in dispute. So the state's proven that. The next one is intoxicated, and by reason of that intoxication causes the death of a peace officer while in the actual discharge of an official duty by accident or mistake, and I'll break that down, is intoxicated. I think the state's proven he was intoxicated. And by reason of the intoxication causes the death of a peace officer. That we have to draw inferences from by the way he was driving that could have impacted this and caused the accident, but I think the state's proven that too. And then we have while the actual discharge of official duties. Well, if she was on official duty, she had made a call to go to the scene to try to interdict or arrest my client. By accident or mistake. This is very interesting language, and when I read this and thought about it, accident or mistake is not a mental state. In fact, every other crime in our penal code in Texas has a requisite mental intent except rape of a child in certain circumstances. Otherwise, everything else you got to have a mental intent. Here, the mental intent is irrelevant because it's a mistake or accident. Well, what that tells you is the state does not believe that Mr. Serrano on purpose tried to kill somebody. They don't believe that. They didn't file it that way. They say accident or mistake. So the question becomes, did the state prove that Mr. Serrano by accident or mistake caused this accident? The answer is they have. They've proven it. So, was this act intentional? I don't believe that Mr. Serrano intended to hurt anybody. But the law doesn't, that's not a defense. It's not an affirmative defense. You can talk about it, but it has nothing to do with whether the state has met its burden. So, my request on behalf of our side is for you to go back and find Mr. Serrano guilty. The state's proven his case. Thank you.
State?
Well, that was an interesting turn of events. One defense attorney told us that you have to take into consideration that the victim was in the wrong place and in the path of the wrong vehicle, and the other defense attorney asked you to find him guilty. So, I guess I need to just clear up a few things before you go back there. Number one, the path of the vehicle. We're having some technical difficulties, so I'll just talk about it. How could anybody get out of the path of his vehicle?
You can take your time. If you want to get your stuff set up, you can take all the
I
time.
appreciate
All
that.
right, no worries.
You'll have the video if you want to watch it again. This defendant very clearly goes over several lanes, moving lanes of traffic, to get to the area where she's sitting. That's not a moving lane of traffic. Why are we victim blaming here? It's not a moving lane of traffic. There are zero reasons why this 14,400-pound truck should be driving into the back of her vehicle. Zero reasons. Being a police officer is a dangerous job. It's dangerous for them to respond to calls. It's dangerous for them to do traffic stops. Ladies and gentlemen, it's dangerous because people like Adolfo Serrano Jr. decide to drive with a blood alcohol content above a .20. That's why it's dangerous. It's dangerous because of the intentional choices that people like Mr. Serrano make. So let's talk about the choices that day. Jennifer made a choice to get up, to kiss her son goodbye, to put on that uniform, and protect all of us. She made a choice to not go get her car washed, but to go help her fellow deputies out. She wasn't even supposed to go to that call. But when that call went out, she wanted to stop him. She wanted to be there. She made that choice to go up there and protect other people. The last choice she made was trying to protect other people. How dare they get up here and say that that choice had anything to do with why she's not here? Let's talk about Mr. Serrano's choices that day. He decided to go to the strip club in the middle of the afternoon. I believe it's 2 o'clock or something that we have our first charge from him at Moments Cabaret. He decided to spend $137 there on drinks and God knows what else. That's a choice he made. He chose to then leave and get behind the wheel of a 14,400-pound vehicle. He chose not to call an Uber or a Lyft or a friend, which in today's day and age is very easy to do. He chose to get behind the wheel of that vehicle and start the car. He chose to drive out of that parking lot. He chose to get on the freeway very heavily intoxicated and put everybody else's life in danger. The choices that he made is why we're here today. Not because of the choices of Jennifer. The choices of that man. And the last choice he made, while she is burning to death, was to try to jump over the wall to save himself. That's the difference in the choices. Ladies and gentlemen, I'm going to ask you to go back there, choose your foreman, and find him guilty. Because he is absolutely guilty of every element of this crime.
That concludes closing arguments. You will now retire to the jury room. You will choose a foreman and you will begin deliberations. Thank you very much.
All rise for the jury.